Hello and welcome to the Emerging Litigation Podcast. I'm your host, Tom Hagy. This is part one of a series that we are calling Agentic AI on Trial, AI liability and legal risks. And our first one is going to deal with insurance claims, efficiency, denials, and ethical challenges. AI, of course, everybody knows this is no headline. AI is transforming a lot of businesses, certainly changing quite a bit. There's a lot of legitimately scary stuff out there, I would say, in the use of AI. Just watch your social media feed. But it's also just powerful and does just so many good things. With insurance, it's no longer optional for insurance companies. It's a imperative to remain competitive. AI now drives claims processing, fraud detection, and even coverage decisions. Intelligent document processing and natural language processing allow insurers to scan and interpret claims in minutes. Predictive analytics tailor policies to customer behavior. But speed comes with controversy. Algorithms at one very large insurance company reportedly denied 300,000 claims in 2 months. It's a lot of denials. And another insurance company, they're going to remain nameless here just for the heck of it, they allegedly terminated care prematurely with a 90% error rate. Who would accept a 90% error rate? No teacher I ever had would. And I know. Lawsuits and new state laws are pushing for human review as a requirement. I think that's a given. Certainly in my business, you have to have a human looking it over. It's powerful, but you want to keep your eyeballs on things. Today we're going to explore efficiency versus ethics, transparency, and liability in automated denials. Those are issues that come up in almost every aspect of the use of artificial intelligence. Our panel comprises Galina Detskovsky, PhD. She's a business strategy advisor. With her is Marina Kaganovich. She's an attorney and compliance advisor at Google. And then we have an actual judge, Judge Lisa Walsh of Florida's 11th Judicial Circuit. I want to thank Catherine Radigan, who's a partner with Robinson & Cole in Providence, Rhode Island. I've had the pleasure of working with her on legal issues with regard to emerging technologies like drones and other things. And so it's a pleasure to work with her again. She pulled this podcast series together for us. And she's also going to give a more detailed introduction of our guests, which is necessary. So with that, here is episode 1 of Agentic AI on Trial, AI liability and legal risks. I should say also that the opinions expressed here are those of these presenters, not their clients, nothing to do with any cases that may be before them. It's strictly their opinions. So with that disclaimer, I hope you enjoy it.
We have 3 leaders in legal, compliance, and technology. We first have Galina Detskovsky. She's an internationally recognized authority in compliance, information governance, AI, data analytics. She has a PhD in computer science and really deep expertise in AI. She advises a lot of organizations on business strategy. She's on a lot of boards. She's just really interesting to hear her background and has a lot of great knowledge to share with this community. She's joined by Marina Kaganovich, who's an attorney and compliance advisor at Google. She also specializes in AI governance, cybersecurity, risk management, and data privacy. She works with a lot of executive leadership teams to talk about how to secure cloud migration in a compliant way. This is an evolving regulatory environment. She's really knowledgeable in that. She does global cross-functional programs for a lot of different organizations as an advisor. She's part of the ARMA International Board. She's really a thought leader in this space as well. And then they're also joined by Judge Lisa Walsh, who is a circuit court judge in the 11th Judicial Circuit of Miami-Dade County, Florida, where she's an administrative judge of the appellate division, and she participates in some international arbitration division as well. She, I think an interesting fact is she's done over 100 jury trials, both criminal and civil. Has a lot of appellate decisions out there, lots of experience, and she kind of brings her judicial experience and insight into this discussion. So they're really a great group, and they represent a big, it's kind of interesting because they converge on law, technology, and governance and justice. Really, all their perspectives are really interesting to put together in this You Be the Judge podcast.
let's talk about an agentic AI scenario in the medical insurance space. And we can kind of facetiously look at this and call it the battle of the agents. So let's assume that we have a situation with an innovation forward medical practice that adopts an agentic AI system that can help it with some common time intensive tasks. And so in this scenario, we're going to focus on an agent that's implemented to interact with an AI agent that's been implemented for similar reasons by an insurance company. And so here we have the two AI agents that are tasked with negotiating insurance coverage for a patient procedure. And so in this case, the medical practices agent is designed to be cautious and conservative and really take a view toward minimizing potential errors and providing comprehensive patient care. And so in reviewing a patient's medical history and test results, the medical practices AI agent, in coordination with the physician, determines that an expensive diagnostic procedure would be prudent given the facts and circumstances. And so submits that to the insurance company that also uses an AI agent to review these types of submissions and determine whether or not certain procedures would need to be covered. And so in our scenario, the insurance company's agent that receives this request declines to cover the requested procedure because the insurance company's agent has really been programmed to minimize costs and to assess the average risk for patients that meet a certain set of criteria, which in this case, it deems that the particular patient has not met. And so we have the insurance company's agent has determined that the threshold for coverage hasn't been met. They decline to cover the cost of the diagnostic procedure. And as a result, the patient doesn't have the procedure performed. And at some point down the line, a serious issue that perhaps would have been identified had this procedure been performed isn't until it's too late and the patient dies. And so we have the family that comes back and sues, claiming that the patient would be alive today if the diagnostic procedure had been performed as initially suggested, if that had been covered by the insurance, because the underlying problem would have been discovered in time and there would have been an opportunity to take some mitigating steps. So let's assume that the insurance company's agent, in line with its really like outcome-oriented purpose to limit costs on a risk-based approach, assigns different weights to the patient's risk factors as part of its evaluation. And so based on that determination, determines that the procedure that's requested by the medical practice agent isn't necessary and denies the coverage. So let's also assume as part of this that when we're looking back on the facts and circumstances, the insurance agent's decision is determined to have been in error. And so in this case, Lisa, what do you think? Who do you think would be responsible with these facts and circumstances? As I'm sure the family would bring suit against both the medical practice and the insurance agent. I'm sorry, and the insurance company's agent.
And the consequences in either can be extremely severe. So the insurance company is supposed to have a protocol that prioritizes that kind of risk over the possible cost in order to avoid that kind of liability. The question that I would have is whether the insurance agent developer included that fail-safe in the model. If the fail-safe were here, your question assumes that the insurance agent abided by the purpose, but assigned different weights to key risk factors. And they're supposed to have a protocol that prioritizes risk over the potential cost when you're dealing with a serious issue. So I think that the likely scenario is, a patient or next of kin would be likely to look at the insurance company, starting with them. Did they appropriately incorporate that risk protocol? Did the insurance company, if they're supposed to have a protocol that prioritizes risk for a serious situation, even though their end goal across the board may be to minimize cost, did they implement safeguards to ensure that that they would flag that kind of a high risk patient, given certain data? Because it seems under the question that they assigned the wrong risks and didn't flag the patient correctly. So that would be the kind of question that is likely to be asked in that scenario, is whether that risk protocol was appropriately implemented by the developer and by the user, by the insurance company themselves. And as far as the medical practice itself, it ended with the agents. So the question is that when the procedure is denied, is there anything else that could have kicked in, to argue the case with the insurance company before just giving up and saying the insurance company refuses to cover this procedure and that's the end of it, you can go out of pocket. There is always an appeal procedure in any scenario with an insurance company where they have denied coverage for something. There is always some mechanism other than immediately filing a lawsuit against your own insurance company to attempt to go up the chain and to appeal. So if the medical practice is the one that's supposed to initiate that appeal to justify, like in the old days, that's what medical practices would do. They would prescribe a particular procedure. The insurance company might reject it. The medical practice needs to justify and explain what is it about this patient that requires more than the common denominator of procedures that you use for patients. Why do they need an enhanced procedure here that is more expensive? Why do you need an MRI instead of an X-ray? That is a very typical appeal process that a medical practice would go through. So the medical practice delegating to the agent, its own agent, and there being no follow-up after the patient is denied may create an avenue for liability against the practice for failing to look after their own patient and going through an appeal process. And as far as the developer, it could be that that there is no obvious avenue for the user, for the insurance company that is using the insurance autonomous agent, that fail safe to identify key risk patients for whom the additional cost should be justified. That issue, that risk analysis may be at the developer level. So the developer should have an avenue that when the system is being onboarded in the insurance company, it's going to be rolled out. What are the policies of the company that you're selling the system to? What are their risk protocols? What are their, very often insurers are governed by laws of the state, not only federal laws. And certain states may require that certain procedures be covered or that insurers communicate in a certain way. The developer level it needs to, or it may be tasked with not everything is cookie cutter, working with your insurance company to ensure that that a fail safe is able to be implemented. There's an additional question that you wanted me to ask, which is, can a medical agent developer be liable for failing to include its own fail safe for when key risks are present? I'm not so sure about that because a system is developed to be used worldwide and every jurisdiction is different. And it may be more dangerous than safe for a medical developer, a medical agent developer to say, we're going to implement our own fail safes here to protect you, the medical practice in a state where you are licensed. I think that may, I would love to hear what you both think, but that may be risky in and of itself to require a developer of the system itself to have a cookie cutter. We will protect you across the board because we will implement our own fail safe here so that under no circumstances could you be held accountable for using our system. I'm just not so sure about that.
Yeah, I kind of tend to agree that it's not on the developer of the system to do that. And I actually did want to ask you a quick question. What about the patient? Aren't they responsible to be their own agent, pun intended? So if they have agency to appeal, why is it between the battle of the two agents? Okay, the agents were developed for different purposes. Now, I think your point in previous podcasts about the standard of care and expectation, you would expect the insurance company's agent to conform to standards of care in the insurance industry, to your point of the jurisdiction. And you would expect the practices agent to conform similarly to the standard of care. So if the practice is trying to just exaggerate something in order to bill the insurance company more, that would be a problem with the agent, or if it's under reporting and under prescribing procedures, that would be a problem. But at the end of the day, the best advocate for themselves is the patient. So I'm just curious as to your comment on that.
In answer to that, patient is always going to be a line on a verdict form depending upon what the facts are. Certainly, I don't know that it's right or fair to say if a patient is a Medicaid patient, for example, or that they're a very low income patient and we're talking about a procedure that costs tens of thousands of dollars, and the patient can't be liable for not going out of pocket because no one's going to perform the procedure on a patient who says, I will not pay you. But if the patient receives a letter from the agent saying, if you want to appeal, please send an email to X and X explaining why this is necessary. Please follow up with your doctor so that you inform your doctor so that they may follow up with an appeal process, and the patient does nothing and is completely passive, perhaps they might be held accountable for some percentage of the harm. So like I said, it's almost never an either or circumstance. Courts are always going to look at who shares the blame for the ultimate harm that occurs. So thank you again for inviting me for this fascinating podcast. And I apologize that I have to log off.
I think we've covered the agents. What's an interesting potential wrinkle to consider as the AI agents mature and evolve is going to be the dynamic learning that's in place. And so, for instance, you'll have agents that are interacting with each other, presumably on a regular basis, and then the degree to which that influences the decision. So meaning like as the agents are interacting with each other, they start to develop some sort of cadence of like knowing, for instance, in our case, the medical practice agent is overly conservative and regularly requests procedures that are, incredibly expensive and for which the insurance agent may feel there isn't sufficient justification. And so I wonder if there's going to be a case at some point that comes up where, depending on the dynamic interactions and learnings between the two agents, there is a potential implication of bias if the denials are coming proportionate to the volume of requests or to the types of requests that come in from specific agents from a medical practice standpoint.
I think you've got a good point. I think that you're right. The agents will learn how the other agents are calibrated and how trustworthy they are, and assign certain weights. And it's already done in certain systems. For example, in evaluating, let's say, various open source intelligence, you would rank your sources, and the agents would actually rank the sources for reliability. And over time, you learn to say, okay, this has been reliable in the past. It correlates to many other people reporting the same thing, et cetera, et cetera, et cetera. So it's already being done to a large extent. So I'm sure that we're going to see that. And by the way, with that, we probably should say, well, what can you do if you are finding yourself, which not if, as everybody is finding themselves in rolling out AI systems and certainly agentic AI as well. And that's clearly going to be continuing and will become more and more prevalent. Some things to think about as you do it. First of all, agentic AI in general requires a shift in thinking. And I hopefully through the series of podcasts, we kind of showed you what to think about, whether it's about how the agent was trained, what the agent is doing, where are the fail safes, what's reasonable, what does agency as the legal term mean in agentic AI. Those are what if agents are interacting with other agents, what if they're layers of agents. So there's a lot of things to think about which are a little bit different, and liability may be different actually. Also, one thing that we didn't discuss, but it's very important to think about, is that security and cybersecurity and protection has to be rethought, because an agent could try to break into a system using an agent or compromise an agent. And so when we talk agent to agent interaction, that could also be a bad actor agents trying to break your security. Obviously, it's a subject for a different podcast, but you need to think about that as well. Also, if you're using publicly available data for your training, understand when there's faulty data or when it's intentionally or inadvertently introduced. So how does that deal with that? And actually maybe ask those questions of your developers. Data hygiene is critical if you're using your own data to train your agent, which is very, very common. Is your data good? Is it accurate? Because again, when we talk about liability, if it's your own data from your own, let's say, test results in the medical system, is it clean data? Are they correct results? Are they the best you have available? Are there multiple bad data elements that you're feeding in? So take action now to avoid problems later. So there's quite a few different things to think about. Have clear objectives, identify specific problems that you want the agent to solve. So be very clear about your goals. Be very, very clear about your data quality and prepare your data, because it's almost always going to be learning on your data. Obviously, consider any ethical implications. I already talked about security quite a bit. Another thing that is important to take away from everything we said is explainability. So understand how your agent makes decisions. If something goes wrong, how are you going to explain it? If you do have to testify in court, do you understand how the system works? And that's not a funny question. Is it a black box or is it explainable how the decisions were made? So if your system is explainable, it doesn't only build trust, which is very important, but it allows better debugging, better improvement, and better presentation should you find yourself in front of a judge. Obviously, the integration into various other existing business systems is a very important thing to consider when you're rolling it out. And I think we also mentioned this, but it's worth pointing out that continuous monitoring and evaluation and fine-tuning will help the system learn different circumstances and adapt to different circumstances, and will ultimately give you much better results, as well as adapt for new paradigms to that.
Yeah, I'm in full agreement with all of those aspects. I think maybe just kind of taking a macro level view of it. I think it's just really important to make sure that when we talk about agentic AI adoption, we're not looking at it solely as like a technological innovation. And yes, it is a tool, it's a workflow that's going to require some changes. The autonomous aspect certainly presents some novel questions, as we've been discussing. But I think overarchingly, it's very much an organizational change management imperative. And that's something that I would suggest that when organizations look to adopt AI, Gen AI, agentic AI, et cetera, they're really looking at it holistically and making sure that they use inputs from various groups. They get different perspectives, but they're also looking at it from a programmatic approach where there are various aspects of adopting AI that are reviewed by different types of teams. So you'll typically have like a security team looking at something. You'll have a compliance team looking at other aspects. And so in order to make sure that this is done well, because that interconnectivity really is quite impactful and unique, it's making sure that the structure of AI governance reviews takes that into account. And so how do we make sure that, be it a working group or a committee or some other mechanism for reviewing AI adoption in the enterprise, how do we make sure that their various assessments are interconnected and flow into one another, so that they really are comprehensive at taking that global view, as opposed to siloed for each group or team within the organization that looks at things from their specific points of view?